Good morning, everyone. Thank you for taking a time out of your Monday morning to come and learn about non-payment of rent and evictions. I know that last time we had technical difficulties and we had to push our Airbnb presentation to another day, and we'll do that again. But this presentation will do non-payment of rent and evictions. For those of you who haven't done so, head over to our social media. Like us, follow us on Facebook and Instagram. We always tend to update you with what's happening with the landlord and tenant realm. That QR code at the bottom left corner of your screen, if you have a smartphone, scan us to add us directly to your list of contacts. So let's get started, everyone. My name is Bita Di Risi. You already should know me by now, so I won't give you I won't bore you with anything about myself. As many of you know me already. For the purpose of this presentation, everything we discuss is for information. If I can ask you to be kind enough to hold all your questions to the very end, and then we can hold a Q&A. You can ask me anything. So let's talk about whether or not your tenant paid the rent this month. Okay, so we're going to talk about different type of rent periods, but for the purpose of these slides, we're going to pretend that rent is due on the first of the month, okay? So rent is considered late if it is paid the day after it's due. So I never recommend that a landlord wait in order to go after rent arrears. So don't wait to start the process. Serve the notice as soon as possible. Okay, and like any other notice, the N4 must be free from any errors. Okay, so no matter how minor, we're going to dissect the N4 throughout this presentation. I'm going to point out certain areas where errors are more commonly found. So this is what the N4 notice looks like. So the screenshot on the left is the first page of the N4. The screenshot on the right is the second page of the N4. Okay, so just by looking at it on its face, you're probably wondering, why or how would anyone make any errors? And, it looks pretty simple. The reason I say that as realtors, you shouldn't get entangled with these legal notices is because, number one, you don't know the requirements and consequences of these notices. Number two, your errors and omissions will not cover you. And number three, I can guarantee you that if there's an error, your client will point the finger at you. Okay, so this is what the notice looks like. Let's talk about parties to the notice, because now we're going to start to dissect the N4. So when you're listing the names of the tenants, include all of the tenants on the lease. Remember, the tenants on the lease. In case of any verbal tenancies, because we know that not everybody has a lease, only include the names of those who've been paying the rent. Don't include, there's no need to include elderly parents who are occupants or children. If your tenant uses a nickname or if they have a shortened name, include both their legal name and their nickname on the notice. If you have a joint tenancy, so for example, if there are two or more tenants on one agreement, you should make sure to include all of the names on the N4. And the same applies to the landlord. The full names of the landlords should be included on the N4. If they have nicknames, that should be included on the N4. If they have shortened names, if, for example, their name is Antonio and they go by Tony, it should be Antonio Tony, right? Again, occupants are not required to be included in the N4. Let's talk about the address, because one of the common mistakes made on an N4 is the address. It is very, very, very important for the address of the rental unit to be included in its entirety. The full address must be specified. So if there's a unit number, if there's a basement, the unit is second floor, back rear apartment, we must identify exactly where the tenant is living. Okay, so if you put, for example, 123 Sesame Street, and you forgot to put basement unit, well, that automatically invalidates your notice. So your notice will be void because you didn't specify exactly where the rental unit is. These are very important details that you must include in your N4. Let's talk about the termination date. Okay, so the N4 notice is a 14-day termination notice. It gives the tenant basically three options. Option number one, pay in full all the arrears owing in order to preserve your tenancy and continue living in the property. Number two, move out of the unit by the termination date. Or number three, you can ignore, or the tenant can ignore the notice, and then the landlord has to proceed to file with the Landlord and Tenant Board. So moving on to page 2, this is where the most 99.9% of errors are made on the second page, the rent arrears calculation. This is a screenshot of the second page. On the left side, as you can see, the rent period, and then you can see date from to, okay? That is where 99.9% of the errors are made. That section has to be filled out correctly. Usually when I'm reviewing the leases, a lot of realtors make mistakes, and I'll tell you, the number one mistakes that are made is that the rent period starts, let's say, from the 1st of January 2020 to the 1st of January 2021. That is incorrect. A 1-year period is from the 1st of January 2020 to December 31st, 2020. Okay? 1st of January 2020 to 1st of January 2021 is incorrect. So for the purpose of this notice, let's say, for example, the tenant didn't pay for the month of July. The notice period or the rent period has to be for July 1st to the end of July if the rent is being paid on the 1st of the month. It's not going to be from July 1st to August 1st. That is incorrect. Okay, that must be filled out properly. So if the rent is due, again, on the 1st of the month, the last day of the rental period is the last day of the month. So if it's due on the 1st, the last day of the rental period is the 30th or 31st. If the rent is due on the 15th, then the last day of the rental period is the 14th. It's never the 1st to the 1st or the 15th to the 14th. Signature. So again, I'm going to start off the slide by saying realtors and property managers cannot serve the N4, not the N12, on behalf of their clients. Okay, so you cannot get entangled with these notices because, quite frankly, you're not licensed to provide legal services. So who can serve this notice? Only the landlord or their legal representative can serve this notice. That's it. If there are multiple landlords, only one of them needs to sign the notice. And the date next to the signature is the date that the notice will be given or sent out to the tenant. If there are multiple tenants, all tenants must be served. So you must photocopy the notice and serve all tenants. And of course, a copy must be kept for the landlord's records. So what else do you need to know about the N4? Remember, anytime I give a presentation, I give you the information that you need to know, just the general information, but the important sections of the notice or requirements of the notice. One of the requirements of this notice is that only rent arrears can be listed on the N4. That's it. Anything else will make this notice defective. So what is anything else? So usually I get asked, why can't we claim outstanding utilities on an N4? You cannot claim outstanding utilities on an N4 because the N4 is a notice for non-payment of rent. If you've already served your tenant with an N4 and then another month becomes due, you don't need to give a new N4 as long as that N4 notice period, the original notice period, is within the 30 days of filing with the Landlord and Tenant Board. Okay, so if you filed, and I'm going to go through this in more detail, if you filed the application with the board, a landlord is not required to serve additional N4 notices because you're going to be updating the arrears on the day of the hearing. So multiple N4 notices are not required if the first N4 has been filed with the board. So the landlord has filled out the N4, they're ready to serve it. How do you serve the N4? How do you serve legal documents? One thing I really love about the real estate industry is it is evolved with technology. And what I mean is that you're using your smartphones to take pictures and scan. You're using e-signature documents to sign agreement of purchase and sales. Your client doesn't even have to be in the country to sign anymore. They can just do it on their smartphone with their finger. However, the wheels of justice spin very, very slowly. And what I mean is that landlords must serve their tenants in accordance with the rules of procedure of the Landlord and Tenant Board. So a landlord may serve their tenants in one of the following ways: handing the document to the tenant, handing it to another adult in the rental unit, placing the document in the tenant's mailbox or where mail is usually delivered, sliding the document under the door or through a mail slot, faxing it to the tenant's business or place of residence, or by courier, registered mail, or express post. Now, another reason why I don't want you guys to get entangled with serving legal documents is that if you're serving the document via mail, any form of mail, registered mail, express post, additional days must be added to the termination date. So now this makes the 14-day termination date to a 19-day termination date. However, if you don't know that and you inform your client that, they can just count the 14 days and just mail it. When they receive the notice in the mail and they disclose it to the adjudicator will dismiss your application because you didn't add the additional days as required to the notice. So what's a certificate of service? You're probably thinking, how do they know how the notice was served? Well, this is what a certificate of service looks like. Okay, so this is a screenshot. So on the certificate of service, you can see where my arrows point, who was served, the method of service. As you can tell, email and text message is not in the requirement methods of service. And at the bottom, you're going to see who served the notice. That is how they're going to know the realtor served the notice. Now, I'm just going to make something clear. Although the certificate of service says representative, it is a legal representative. That's what that representative means. It doesn't mean realtor. It doesn't mean property manager. It means legal representative. When do you file the N4 and the certificate of service with the board? So the N4, they can be filed with the Landlord and Tenant Board by way of an L1 application. Okay, so the N4 certificate of service and the L1 gets filed with the Landlord and Tenant Board, and then you wait for a hearing date. So if the N4, however, is not filed within 30 days of the termination date, that notice becomes void automatically. Okay, this is really important. So if it's not filed within 30 days of the termination date, the notice automatically becomes void. However, once it's filed with the Landlord and Tenant Board, it will get put in a queue at the scheduling department, and you're going to have to wait for a hearing date. Let's talk about delays at the board, because if you have a landlord who hasn't been paid for months or a year or 2 years, this can be detrimental because they're incurring thousands in arrears. So pre-COVID, it took an average of about 4 to 5 months to get a hearing date. As you are all aware, the board shut down between March 16, 2020 to August 1st, 2020. Currently, the average time to receive a notice of hearing, it was 9 to 12 months. However, I'm very happy to say that the board is working efficiently throughout the backlog. So currently, it can take anywhere from 5 to 6 months to receive a notice of hearing. What does a notice of hearing look like? This is a screenshot of what a notice of hearing looks like. So as of August 1st, 2020, the Landlord and Tenant Board started holding video and telephone hearings for landlord applications, more specifically, the N4 for non-payment of rent. Now, anyone can attend a hearing. Okay, if you're a party to the application, you must attend a hearing. You don't have a choice. If you want to attend as an observer, you can also attend as an observer and just listen in. However, if you're listed as a party, you must attend the hearing, or you must send a legal representative to attend on your behalf. If you don't attend, or if you don't have a legal representative attend on your behalf, the hearing will go on without you. And I can promise you, you're not going to receive the outcome that you were expecting. Again, on a non-payment of rent application, parties are encouraged to work together to put together a repayment plan for the arrears. Under a section of the Residential Tenancies Act, on the date of the hearing, the board member will ask you, as a landlord, what have you done to contact the tenant in order to put together a repayment plan? You have to be able to inform the board that you have exhausted all avenues to try and get a hold of the tenant in an effort to put together a repayment plan. This is very, very important, because if you don't, and if the board is under the impression that you haven't been accommodating to the tenant, then they will set a payment plan. And again, this will just add delay to your eviction process. On a non-payment of rent hearing, tenants can raise certain issues under Section 82. So Section 82 of the Residential Tenancies Act are basically pertaining to issues that a tenant can raise at a non-payment of rent hearing that gives them the opportunity to explain their position. Why haven't they paid the rent? So the tenant can raise these issues involving arrears of rent at the hearing, and more than likely these issues are maintenance concern, illegal charges, the landlord hasn't repaired anything. These are issues to basically justify reasons as to why they haven't paid the rent. I view this as a delay tactic, because if your matter cannot be heard because of these issues, or you need to address these issues, then the board will adjourn the matter. So they will set it aside for another date. And this will usually add another, 3 to 4 months to a future hearing. Now, this is a screenshot of Section 82 issues that a tenant can raise at a hearing. This is exactly the form that we receive it from the board, exactly as what it looks like. So it will allow the tenant to describe the issue, when the issue started, when they informed the landlord, it hasn't been resolved, and what does the tenant want to see the board issue, an order that the board issue or take into consideration. I'm going to send a copy of this presentation to Tina, and she can send it over to you guys. You can have a look at it, and it will give you a better idea. It's a great read, because now you know how to advise your clients or inform your clients as to what can happen at the board. Because even though your clients have, in the back of their head that they're going to a non-payment of rent hearing to get an eviction, I can guarantee you they're not going to get an eviction right away unless the tenant does not show up to defend their application. After the hearing, the board member will send out an order, usually within 30 days. So what does an order look like? So this is what an order looks like. The left side of the screen with the bolded stamp is an official order of termination of tenancy, or the board member's order. Okay, an original copy of this order, it must be filed with the sheriff's office, so the enforcement office, in order to book a date for an eviction. Okay, again, the tenants have an opportunity to be heard. So for example, if you have a tenant who didn't receive the notice of hearing, or for example, didn't show up at a hearing for whatever reason, tenants can bring a motion, and a motion is basically a request to the board or to the courts to do something. Tenants can bring a motion to set aside an order. And basically what they're doing is they're putting a hold or a stay on an order. Within 10 days from the date that this order was issued from the board, basically, they're going to be putting a hold on the order or stay on the order so that another hearing can be held and they can explain the reason as to why they feel that they should not be evicted. Again, this is another delay tactic. This will buy the tenant probably another 4 to 8 weeks. Let's say, for example, the tenant didn't put a stay, they breached the order, you filed for eviction. What happens on the day of the eviction? On the day of the eviction, this is a picture of the court enforcement officer, so the sheriff. That is the uniform that they wear. They do not carry guns. So the sheriff will meet the landlord or one of our legal representatives at the property in order to carry out the eviction. The picture on the right is a notice of vacant possession. That notice is posted on the door. You can see the official court seal on the top left of the notice to vacate possession. That is posted on the door. On that eviction date and time as specified in that notice, the sheriff arrives to evict the tenant and possession is given back to the tenant. Sorry, possession is given back to the landlord. Even though the landlord has control as of the day of the eviction, the tenant still has their belongings in the property. So what happens to the tenant's belongings? So I call this the aftermath, the 72-hour rule. Landlords must provide tenants with access to the property for 72 hours in order for the tenant to remove their belongings. After the 72 hours, the landlord can do whatever they like to the whatever's left behind. They can dispose, they can sell, they can keep any of the tenant's belongings. So now you've gone through the procedure to evict the tenant for non-payment of rent. The sheriff has evicted the tenant. The tenant owes you thousands of dollars. If the tenant is lucky and you're lucky enough to garnish their wages or their bank account, that is the only way that you can collect the arrears, by way of garnishment of their wages or bank account. So if for example, the tenant is not working, or if they're on Ontario Disability or Ontario Works, you won't be able to garnish their wages. So we're coming close to the end of the presentation. For those of you who haven't done so, this is a copy of our Landlord Mastery. If you download it, it gives you access to our Google Drive account, which Rob updates regularly. It's full of forms, scripts, other agreements. This is a great guide to help you in your business, and you can forward it to your clients.
Thank you so much for watching. If you like our video, please hit the like button, the subscribe, and even the little bell to get notifications, just so you can stay in touch and watch more of these great videos.